Anyenini is he manages a firm of 4 members and currently has 2 pupils. He has been vice president of Young Lawyers Forum, been on the school management committee of the University of Ghana Law School. He's a board member of ILAW, International Lawyers Assistant Workers. He's with us on the phone lines. He couldn't come to studio. Good morning, Samson.
Morning, Daniel.
Right. We would have loved to have you in here, but we understand you have courts this morning, so you can't. You couldn't come to Kokom. Roxanne Nelson Dafeamekpor is a member of Parliament for South Dai. He's a member of the Judiciary Committee and Committee on Constitutional, Legal and Parliamentary Affairs of Parliament. He has also been president of the Young Lawyers Forum. Good morning, Mr. Dafeamekpor.
Good morning, my brother, and good morning to Samson.
Morning, Roxanne.
Let me begin with you very quickly on this, Samson. Educate us first of all on what pupillage is, its requirements, and its the rules and regulations. Can you do that in a minute, please?
That's not possible in a minute. But what I'll say is to try and give you an example that on Monday I was driving together with 2 of my pupils and my clerk to the court. Then we got to a point and a trotro driver who never signaled to show that he was turning to our left on that one one lane, started insulting me because I tried to move to the left side. He just started insulting. So all of us began to ask the question, really, you have no signal. There's no indicator that you are turning this way. And yet we have been blocked, so we need to move. How come he's insulting? He won't listen to anybody, but he kept insulting. Here is the lesson. We asked the question, so this guy has a driver's license. So who trained him? He must have done an apprenticeship. Who trained him? Much earlier on in the firm where I read, and read under Charles Zwenis in David Zwenis Use and Co. in Osu. I was assigned a job to deal with a divorce case for a white man who lives in this country. And he asked me a question one day during the process. After the process, he asked me, "Are you married?" And I wasn't married. He asked me, "Do you have children? Do you have a kid?" I said, "No, I don't." And I understood why he asked the question, because his children, custody was an issue, and he felt that he needed someone with some better experience than someone who is not married, who may not have a better understanding of the system. Now, when we go to court, there are times when judges and clients have had to speak to lawyers, and they tell them about how the person from your firm is doing or is not doing. So your name goes out there because of the people you teach. The law says that once you have completed your bar exam, you are not issued your license, and it's subject to you doing at least 6 months of pupillage, and I'm understanding that may have been improved upon. And you must do it under a lawyer. You must do not less than 6 months, and you must do it under a lawyer who has done not less than 7 years at the bar. The requirements of being a pupil are very enormous from the time that I understood pupillage. So that I knew that I was not an employee, and I knew that I needed to do something so that right after my pupillage, I'll be guaranteed a job in the firm. Because you would often go to a firm where you pray that you would belong to after your pupillage.
Okay.
Now, as a pupil, you will do loads of work because you are now beginning to translate much of the theory into practice. You are beginning to see, at first hand, how documents are prepared, how clients, meetings are held, conferences are held with clients, how information is elicited and transformed into documents put in a courtroom, how to even go and argue your case out, and the process of how to do all of that and do it in a way that solves problems and pays the bills.
Right. Right. So that takes us to, and thank you very much, Samson. On that point, let me come to Mr. Dafeamekpor in studio. You have put out a statement, and you say their constitutional rights have been breached.
Yes.
I have read through this statement about 3 or 4 times. You didn't point to the specific rights that were breached. Can you help us with that?
Very well. Let me, maybe with time, I will get the opportunity to also expatiate on what the nature of pupillage. Now,
you can touch on that briefly
okay.
in about 30 seconds before you go on.
The nature of legal practice, and to the extent that we are talking of pupillage, is such that it is not every work that ends up in the court. It's not every legal work that ends up in the court. As part of our calling, we are also supposed to be solicitors. So we do solicitation. We do a lot of drafting in your early stages. And you acquire the skills of drafting properly if you apply yourself to the job during your pupillage. So I am wondering why, given the nature of legal services available at Legal Inc., they couldn't allow these 2 ladies to even do a lot of drafting, a lot of sedentary work. You know, pregnant women like to be sedentary. They sit at one place and work. And a lot of the legal work, when you leave the courtroom after about 2 p.m., that's not the end. We do a lot of the work deep into the night. And these are ladies, I believe, who are capable of doing this. But we'll get there. Now, if I may refer you, first of all, to Article 27 of the Constitution, and it is to this effect, 27.1. Special care shall be accorded to mothers during a reasonable period before and after childbirth. And during those periods, working mothers shall be accorded paid leave.
Okay.
Do you understand my point? And the emphasis that I'm laying on this matter is in respect of period before childbirth. And the period before childbirth is certainly when you are pregnant. Undoubtedly. Now, let me also take you to Article 17. From 27, we are going to 17. 17.3 or 17.1 says, all persons shall be equal before the law. 2, a person shall not be discriminated against on grounds of gender, race, color, ethnic, blah, blah. So in this case, it is gender.
Okay.
And 17.3 says, for the purposes of this article, discriminate means to give different treatment to different persons attributable only or mainly to their respective descriptions by race, place of origin, political opinions, color, gender. Again, emphasis is on gender. So I'll leave it there.
On Article 27.1,
Yes.
Specific reference is made to paid leave.
Yes.
These are not full-time employees.
You see,
Are they entitled to paid leave?
Hold on.
About
paid
full-time,
leave is just
they're not
one of them.
employees.
Yes.
So they are not even Samson just made an input that I want you to make clearly for us. You were saying, Samson?
I was saying that you said they are not full-time employees, and I said they are not even employees. The apprenticeship or the training that you get during pupillage somewhat is a privilege. You go to England today, where now we are crying about entry into the law school. Much of their problem is actually about getting opportunity to do pupillage so that you can get certified to practice.
So does it then mean that, Samson, they don't enjoy some of the privileges in Article 27.1?
When you are reading provisions that relate to working people, when you are reading provisions that relate to employment, and you are relating it to people who are under apprenticeship in the manner that we are looking at under training, I think it is wrong. It's a false start.
May I react to that?
Yeah, go ahead.
May I react to
Go
that?
ahead.
It is wrong for my brother to construe 27 as not applicable in this matter. They have made special arrangements in the firm where they pay stipends. And stipends is a form of earnings, where you, by the nature of the arrangements, you give them allowances. That is a form of earning. So for me, you cannot say, indeed, if you go to the labor law, there are circumstances, it's covered under the labor law. Do you understand my point?
So you believe the firm has done so much wrong?
I am saying exactly so. Particularly when it is a law firm.
Okay.
They couldn't have done what they have done. That is why I'm calling upon the bar and the General Legal Counsel to direct the firm to recall them back. Because it sends a very terrible signal. Are they saying that in the event that they finish the pupillage and they become full members of the firm and they become pregnant, they'll be subjected to the same treatment?
But isn't it the firm's choice to pick people to be their pupils?
Exactly. This is an arrangement that is done by the General Legal Counsel.
Samson, just a moment. I'll let you bring your
the General Legal Counsel in consultation with the Ghana School of Law. So now, before you become a pupil of a firm, you are interviewed. During our time, we joined firms of our choice. And then at the end of the statutory minimum period of 6 months, a report is sent, and then we apply for our license. Now the statutory period is 12 months. Is this firm saying that the pregnancy began at the time that the ladies were with them? But the record shows that they've just done 2 months. So they have been pregnant even before they joined the firm. So why did you in the first place accepted them?
Samson wants to bring in
to add put information out there that the best of my knowledge,
Samson, just a second,
from the way things are, it doesn't appear the firm knew about their pregnancies.
Okay.
Yes, but the question I put to them, which they gave some response, is the fact that if you are a full-time lawyer and you are pregnant, they allow you to work. And one of the reasons they gave was that because these people are pregnant, sometimes they are giving cases. They are not sure whether they will even be able to go to court. So I asked, but your full-time lawyers also are giving cases, even bigger responsibilities.
Manasseh, let's hear the other voice on this.
Let me add to Manasseh's point.
I feel like we are crowding out Samson because he's on the phone. Let's bring him in on this point. Samson, go ahead, please.
Now, once again, I have to stress, and with great respect to my friend Roxanne Nelson Dafeamekpor, who I was vice president on the Young Lawyers Forum, which we have long outgrown. And if you are an employee, you're entitled to the leaves that accrue to you as a result of pregnancy and all of that. I think he's misapplying those provisions in the manner he's doing them now. And let's not kid ourselves. If I, as a pupil master or the lawyer who is overseeing and supervising your pupillage, if at the end of the day I cannot faithfully, in good conscience, certify that you have undergone the process in the manner that is expected of you, I should be in a position to advise you. It is not up to you only to tell me that you are capable, when I know I am supervising you and can tell that you are incapable. I think what is wrong here is that we are seeking to suggest that by mere discovery of pregnancy, then the firm decided to take a decision. But if you listen to their side of the case, it was not just a question of just pregnancy. And the story that goes out on social media and as also have been put out by Manasseh appear to have suggested that you have women who have lost their jobs simply because they are pregnant. That clearly is not the case. Look, I don't know how that firm conducts its pupillage, but when I was a pupil, Look, I have watched my wife also go through pupillage, okay? And let's be fair and sincere about the matter. When you have been asked to defer so that you can continue and complete at another time, if this is mutually discussed very nicely with a good understanding, there ought not be any problems. But at the end, the one who must satisfy, whose integrity is on the line, who may even as a pupil master lose his license, who may even lose his name from the role of lawyers and will not be able to practice anymore because he has been dishonest. The onus is on him to make a determination. And these claims about whether or not they needed to use medical reports does not even come in.
Why not, Samson? The medical doctors are the professionals, aren't they?
They are the professionals. They are not the ones supervising your work in the firm. They are not the ones who will certify at the end that you have been able to do the work. You see, and it's not just about attending to the firm and sitting in the firm and being given work that does not give you.
Samson, I have a question for you from a listener. Hi, Daniel. I would like to, and this is a lawyer sending in this one. I would like you to ask Mr. Anyenini if the arguments that the pregnant woman won't be able to fully participate in the training and thus the firm can't lie for them can be issued with licenses, can be extended to the pupil who will only be available for pupillage for a period of about 8 months. Is the firm ready to lie that he satisfied the requirements? The pupil who only shows up for work 3 times a week will have spent a total of about 8 months.
What do we know about the arrangement for whichever pupil comes into the firm? I have supervised a pupil for more than 1 year. The law does not say let them do 1 year. I have supervised a pupil for more than 1 year because I am not satisfied at the end of a year that pupil deserves, is ready for the bar, properly so called. Okay? And that responsibility is mine. My integrity is on the line. And that pupil agrees with me that due to his own circumstances, a year was not enough. So he had to do sufficient enough for me to be convinced that once I certify him, wherever he goes, my name will pop up.
Samson, hold on just a second. Hold on just a second, and let me come back into the studio. There are some responses to the statements you made.
Yes.
Mr. Dafeamekpor.
Yes. First of all, by a court of appeal decision now, even pupils can't move simple motions even in a district court. Pupils, during your pupillage, you can't even move motions. So we are barred from even conducting cases. That is why I am of the opinion that the nature of pupillage now is such that the ladies could even operate from home.
So they could have found work for them
exactly
to
the
to
same
fix
arrangement that they did for the immigration chap. They could have done a similar arrangement for these women. And look, my brother, the Constitution speaks of working women. And I'm shocked Samson is saying this. Constitution says working women, whether temporal working women, permanent working women, or ephemeral working women. Constitution simply says before childbirth, make special arrangements. Don't discriminate.
Manasseh wanted to make a point about the nature of the story.
Yes, what Samson said, if you read the story, everything that the law firm issued in their rejoinder is in the story, including the reasons they gave in the letter, and then the reasons they gave when I interviewed them.
Okay.
So their main point is, once the ladies were bound to deliver before the 12 months, before the 12 months, then there was no need keeping them. And the question is, okay, so does it mean, and this may not be the fault of the firm, if we are saying it should be 12 months continuously, that's when the pupillage should be, does it mean pregnant women cannot do it? Because if you become pregnant within the period, and sometimes somebody doesn't know they are pregnant until a month or two. So
I'm coming in on this point because if the fact of the story that you narrated
Yes.
when we were starting hold,
Yes.
that means that the firm was willing to let them do 3 months, go home, come back and continue. So there were never 12 continuous months.
No, and the firm even said this on a recorded interview with me.
Okay.
But when they issued a statement yesterday, they said it has to be continuous.
Okay, let me come to Samson on this one. The point that Mr. Dafeamekpor made that they can let them work in sedentary positions from the office, work that is not too stressful for pregnant women, that can be done.
It was legal work.
And it's still serious legal work. So, Samson, what do you say to that?
I don't have a disagreement with that. You see, as I mentioned earlier, it has to be a mutual, position. And it has to be one that advances the cause of the firm and also for the welfare and the best interest of the one being trained. If you read from the side of the firm, it is for them to make that determination that we have seen you in exhibit conduct as a result of pregnancy. They are not saying because you are pregnant. As a result of pregnancy-related matters that have come up, we have seen at first hand how you are in difficulty, and therefore we are asking you to defer. They are not saying go and don't come back. We are asking you to defer, take good care of yourself and baby, and then come back to continue. If you disagree with that, I think you can mutually, terminate your relationship with them, look for another firm, and join them, if that is what works for you. But I will repeat that the decision as to whether or not you are performing and you are capable or not rests with the one who must certify at the end that you indeed have done what is required. If their view is that they cannot allow you to sit at home and work from home for the purposes of what they are seeking to train you to do, so be it.
Is it their choice?
About it.
Samson, is it their choice to say that we can't give you work that will enable you to work when you are pregnant? Is that a choice that the law firm has to make?
No, it's not that because you are pregnant, from what we are reading. Look, and you will check, these days, the females appear to even outnumber the guys in
the legal profession.
For pupillage.
Actually, that's on the roll, yes. At the bar, there are more females.
I can testify to that.
Yeah.
And the biggest law firms in the country, if you look at them, the numbers of females, are more than males. Now, it's about how the firm managers agree with the women who come in and may have issues related to pregnancy. In the first place, if you are pregnant and they take the view that because you are pregnant or you are expecting, they will not take you in, that is it. You cannot force them to take you in. But I take the view, and I have had in our firm, we have had a policy that is so favorable to women. But I insist that Roxin cannot continue where he is, insisting that they have broken some law when no law has been broken. They did not terminate their pupillage. They told them that we have seen your situation. There have been circumstances we have seen you have been unable to work. On the basis of that and in your own interest, we ask you to defer. It is not for the firm to say you are supposed to work, you are supposed to do the pupillage. It's not about the period that you do the pupillage. It's about the period that the pupil master is satisfied.
Okay.
That
Samson,
you are ready for the bar.
Samson, yes, hold on again. There's still a lot more response coming in from in the studio. I want to bring that on air. And just to make this quick points before I come to Manasseh, I think that the lady's argument that has been made is that they want that choice to be theirs. They want to choose if they can work, and not exactly the firm. Manasseh, you said you want to make a factual point on this one, based on the story.
Yes,
Okay,
and,
I'll come to you,
not
sir.
just the fact that they have to decide, but they also feel discriminated against because what we talked about, the immigration lady, there's another lady who also absented herself more than these two, but they said hers was not pregnancy. It could be they were able to treat it and she got back to work. So yes, so because there was certainty about hers. One thing about always using this justification that they have to determine whether the person can do the work or not. Let's remember Ghana National Fire Service had a policy in its regulation 33.6 that the first 3 years after recruitment, the work is so rigorous that a woman is not supposed to get pregnant. If you got pregnant, you are sacked. And they justified it because they have their training, they have their work, and they knew how rigorous it was. This case went to court. Shraj led some women to court in 2017. In 2018, the court ruled that this was discriminatory and illegal. Nursing training colleges, they also advanced the same argument that they are training, they go for clinicals and all of that. So if you're a woman and you are pregnant within the period, it is not good. So you were dismissed. We did the story in this studio in 2017. I did that report. The same people who had this argument came back and said, look, a way could be done. So now nursing students who get pregnant are allowed to go through it. If you come to law, the woman I spoke to, I interviewed 3 people at the same time.
One of them was a woman.
Yes, a woman, the deputy managing counsel in charge of human resource. She said in her final year in the Ghana School of Law, she was pregnant. In fact, she delivered 10 days before the final exams. She wrote the exams and she passed. Okay, so the question I asked was, so at that point, if somebody has said, no, the law school is rigorous, you have to attend lectures and all of that, if somebody had denied you this opportunity, they may not have been fair to you. So
that's the point you wanted to make, Manasseh.
Yes,
I get it.
yes.
Martha says I was in school full-time working full-time when I was pregnant with my second child. I never absented myself in any of my endeavors. I delivered, and the following day I was sent in to write my final exams. Hey, the day after you delivered, Martha, that's serious. I passed well too. Please, the woman could do if given the opportunity. Pregnancy is not sickness anymore.
I was just going to say the same thing, that pregnancy is not a disease. I've had 2 children. With my first daughter, I was working as a DHL driver. So I was waking up at 3 a.m., packing parcels, packing them onto a van, driving around, delivering them pregnant till I was about almost 8 months. And I was fine. This was 12, 13 hours on the road. And so to judge a woman or to in the first trimester say, oh, we can see that perhaps you may not be able to, from me, it's actually very, it's very painful because it is not fair. One, if we do not have children, there will be no procreation in the first place. So then are we being punished for what nature requires us to do? And how does somebody outside of your body determine for you that what you are going through will stand in the way of you being able to do what you are going to do or what you think you can do? There's a human life going inside of you. Yes, it doesn't affect anything. I was able to do a very manual job. I know countless women who have been pregnant and have done so many things, even presidents of countries breastfeeding in parliaments. Women are pregnant, they're campaigning. Why is it something that becomes even a point of discussion?
Devil's advocate here anymore. How does someone outside the profession determine the level of wellness required to perform in a certain role?
But these people are in the profession. They've gone to law school. They've gone to Makola, presumably.
They've only done pupillage.
They've qualified.
They are not
And
qualified
then,
profession.
but then wait,
If I
and then
may.
now they are pupils. So
They've
they
only
have
done
an
pupillage
idea
for
of
3
what
months.
it is.
They've
Daniel.
only done
They have
pupillage
an
for 3
idea. I
months.
appreciate your devil's advocates, but they have an idea of what it takes. And they are telling you that they can do it. Are there not pregnant women sitting at Makola selling fish the whole day? Are there not? Are there not
Even
pregnant women
parliament,
sitting in
even
banks?
parliament, we
Are
have
there not
pregnant
pregnant women riding bicycles, going to sell with children at their back, carrying water? Are we saying then that the woman doesn't have the strength?
Let's allow Mr. Dafeamekpor to make his point. please.
My brother, first of all, what Legal Inc. did amounted to constructive termination. You know why?
Termination of
Because
what?
if the two lawyers were not aggrieved, they wouldn't have been doing
Said
this.
exactly.
So once the person is aggrieved, it amounts to constructive termination. That's one. Two, there's no indication of an assessment report indicating that they have assessed their work within the period that they were speaking of and found them to be wanting. No such report exists. Somebody is being judgmental.
Isn't there a suggestion in the statement released by the firm when they say that they have missed work, and even in that statement they say on one occasion one of you had to be driven home by a fellow lawyer?
May I
she was
respond to
dizzy.
that? Yes, may I
Because she was
respond to
dizzy.
that? May I
Please do.
respond to
Please do.
that? Manasseh did say that the two lawyers have contested that fact and said that they only absented themselves. I think once that she absented herself once.
And another 5 days. That she had an excuse duty for 7 days, but she got better and came on the 5th day.
You understand?
And
Okay.
so let me just add this information. When I interviewed them, they spoke so passionately about one of the ladies not being serious for the work, and the reason is that she scheduled a doctor's appointment for the 7th of January. If you play the interview, they emphasized that this lady could have, if she was really serious and didn't care about her baby and her health more than the law firm, she would have scheduled her date differently. And I spoke to this lady and she said, look, January 7 is a public holiday. So I didn't want to go to see the doctor on a working day. So I decided to make it on a public holiday. So if on a public holiday you organize training for lawyers and this person couldn't come, I don't think you should hold it so seriously to use it as a point to add.
But
Okay.
Manasseh, 2 points. One, the symptoms of pregnancy in the first trimester are very different from after the first 3 months. A lot of women may have
And
nausea
even
and
different from a
dizziness
woman to
in the
another
first 3
woman.
months, and it does not continue. So to judge based on that is my first thing. Second thing is I'm getting information that with doctors, with the Ghana Medical Association, when you get pregnant, you get an automatic 6-month extension of your residency. So there is an allowance that is made for something that women have to do. I'm sorry, if men thought that they could get pregnant, I think that we would be very happy to release that responsibility onto them. But it's something that we have to do. And so when that becomes the basis of which, we are being stopped from doing what we want to do, then it is not fair. Because
Okay.
we are having to do this for 9 months. So give us extra time. Yes, it may be equity over equality, but this is what it is. Because last time I checked, you are not able to carry a child. I have to do it.
Mr. Dafeamekpor, finish up your point before I come back to something.
Anymore, I agree with you perfectly. In fact, the law does not even permit that. That's why the law says you cannot discriminate on these grounds. You can't do things, you can't give preferential treatment on grounds of gender. And I'm not being emotional. I am speaking to the law, what the law is saying. And it's very simple. That the law firm in this case cannot do what they supposedly have done.
Okay. Samson,
Daniel.
yes, Samson, please come back.
Daniel, you see, and I hear Enimwa and the rest of them giving very wrong examples here. You see, you have no idea how a law firm functions. You have no idea how pupillage is undergone. As a man myself, when I was doing pupillage, I could be in the office by 5. I could leave the office after 10 or midnight. Sometimes you just can't leave the office even when your pupil master is still there. And if you're in a serious law firm, there will be a lot of work, and you would want to do the work in a manner that there will be attention on you in a way that right after your pupillage, you will earn an automatic, membership of that firm. Look, pupillage is the most important. If you look at it from the training, it's the most important. And from what we are looking at, it is not the case. From what I'm reading, and I don't want to believe one story against the other. It is not the case that they say because you are pregnant. And anyway, he's talking about doctors where there is 6 months extension. Then that is also a case that advances what these guys sought to do. 6 months extension means that you could take a break and resume. So if you can mutually agree with your pupil that because of these circumstances, for your own welfare, take a break and continue, not say go, don't come back. There are hundreds of people who are looking for the opportunity of pupillage they don't have in England. And this is the most important part. They need that, and they need that to be able to acquire the certificate to be able to begin their life and to begin to earn some money for themselves in the practice. You can't tell me that if I examine a pupil who, by reason of pregnancy-related illnesses, will not be able to keep to timelines, will not be able to keep to meetings, that I should still entertain when I feel discomfort, that I should still entertain when I cannot, at the end of the period, certify that they have faithfully, I cannot faithfully certify that the person has done what is required of them. Please, let's not, stick to, as it were, promote the issue under the greater question of how women are treated. That is not the issue here, from how I see it.
Samson, I have here a message from a lawyer who says 2 years ago, Justice Anthony Yeboah, the late Justice Anthony Yeboah, gave a decision in a similar case with 2 women working for the fire service, and where they were dismissed for getting pregnant. Now, Strash Grace Fosu and Thelma Hammond v. Ghana National Fire Service. Now, in that case, the objective test for determining whether or not there has been discrimination was that is the person protected by the relevant law on non-discrimination? Has the person or group of persons been subjected to adverse treatment? Are any of the grounds a factor in adverse treatment? And is the adverse treatment reasonably justified, legitimate, or proportional? Where the answers to the first 2 questions are positive, the conclusion will be that the applicant or the complainant has established a case of discrimination, and the respondent will be called upon to reasonably justify the interference with the protected right.
Under what circumstance?
You would have to show cause.
Under what circumstance and under what relationship?
You would
when you have a pupil, when you have an apprentice you are training, look, it is your job to train them. It is your integrity out there. And it must not, once again I stress, it is not about the period that you go through. It is not like if it is 8 months or 1 year, you must do continuous 1 year and that's the end. And the pupil master is obligated or is under obligation to certify at that point that you have done it and you have completed it. It's not about completing it. It's about a satisfaction on the part of the one mentoring you.
Right.
That you are ready for the job market.
So Samson, quickly on this one, are they not protected by any laws at all when they are under pupillage? Is there no part of our law that protects people who may feel discriminated when they are in this period?
Daniel, you come into pupillage because it is mandatory on your part to be able to enter the profession and to practice. On the part of the law firm, it is voluntary. It is more like a favor to you.
So they are doing you a favor. Because they are doing you a favor, Samson, does it mean that you can't...
Just wait.
Okay. I'm waiting, please. Sorry.
Look, I have just given you examples of an example for myself. You see, when you talk about somebody at immigration, you may need to go and find out what hours of work they are required to put in, for what period they may also have to put in that work before the lawyers may certify that they are entitled to be issued the pupillage certificate, and from that on they will be able to practice. So that if you have a special circumstance, we can sit down and agree. We can sit down and agree nicely that this is the way we will go about it. I am saying, Daniel, that in this job, pupillage can be loaded, and I am happy. I did what I did, and I didn't complain because I had an aim. There were several seniors in my firm at the time who everybody had work for me to do, and they expected me to deliver that job. The energy you need to deliver the job, the alertness you need to deliver the job. I am saying
Samson,
that if my senior or my pupil master made the determination that at a certain point I was not ready and that I should defer, if I was aggrieved, I will not go to the press. I will try talk to him or get a senior he respects to talk to him or her, or even go to, if you like, the legal counsel, seek for them to work it out, not to go into the media. After you go into the media and you do this public thing, are you able of returning to that place and, doing your pupillage there? I'm saying that there are things that appear to have been done wrongly, and there are positions that were pushed from a false point of view, that their pupillage had been terminated because they were pregnant.
Okay.
Unless we are saying that the law firm is lying.
Okay, Samson, thank you very much for joining us here. Let me make this clear that we made contact with the General Legal Counsel. But they deferred comments for now. And they were very clear and candid with us that this is a matter that may come before them. So they don't want to come and prejudice their positions in public before it comes before them. So, but let me thank very, very much the president and his vice president who came to slug it out here on the Super Morning Show. Roxanne Nelson, Dafeamekpor.
May I add this very critical point? Look, it is not correct that they are doing the lawyers who are pupils a favor. This is a formal arrangement. This is a formal arrangement that under which pupils are assigned to law firms for which the General Legal Counsel expects a report. So you cannot treat these people as if they are non-entities. It is unacceptable.
Roxanne Nelson, Dafeamekpor, Member of Parliament for South Dai, Member of the Constitution, Judiciary and Legal Affairs Committee on Parliament, and Judiciary Committee and Constitution and Legal Affairs Committee of Parliament. Thank you very much. Former President of the Young Lawyers Forum. Samson Anyenini is also a manager of a law firm where he has 4 lawyers under him and he has 2 pupils. He's also a former president of the Young Lawyers Forum, former president and vice president under Roxanne Nelson, Dafeamekpor. Let this conversation continue. What do you think? Do you think these ladies are being discriminated against, or it's a simple matter of a law firm looking out for them, considering how tough it's going to be? It's 8 minutes till we hit the top of the hour here on the Super Morning Show on Joy 99.7 FM. The conversation is just beginning because
it presupposes that a letter was received with the name office of the president. And then when we sat on it as a committee,